Hello and welcome to this unique session. We have compiled information for you, the food safety professional, because we recognize that the regulatory adoption process may not be familiar to those of us in the food safety world. Our forte is in food safety, not in regulatory adoptions. We don't do them very often. So we've created this presentation to make this information as relatable as it can be for you. If there is anything that you would like more information on or clarification, please reach out to us and email us at AFDO if you have outstanding questions, or visit our website for some resources on food code adoption. So let me introduce our speakers for you. We have two attorneys here to present. Steve Mandernach is the Executive Director of the Association of Food and Drug Officials. Prior to becoming Executive Director of AFDO in 2018, he was the Bureau Chief for the Food and Consumer Safety Division in the Iowa Department of Inspection and Appeals. We also have Brad Deacon. Brad is the Director of the Office of Legal Affairs and Emergency Management for the Michigan Department of Agriculture and Rural Development. He also teaches agriculture law at the Michigan State University College of Law and is a member of the AFDO Board of Directors. One standard funding note, this webinar is funded by a project of the Retail Food Safety Regulatory Association Collaborative. So to start things off, I'm going to pass it over to Brad.
Thank you, Deanna. Welcome to today's webinar. We'll start, as you would expect, with some additional disclaimers. This webinar focuses on food code adoption by administrative rule or through the regulatory process. This does not directly relate to the statutory adoption, which many states do as well. The webinar talks about general principles and is not legal advice, either from the funding provided by the FDA or from AFDO or from me. Each state may be different and probably is, so always verify your state's requirements when it comes to rulemaking. To start off, we want to talk a little bit about things that we may not have spent much time on since government class in high school. And we'll start with constitutions. The Constitution, and this is parallel for the U.S., for the whole United States, as well as in each of the states, constitutions serve as a framework or set of fundamental principles that then all governing bodies underneath them operate under. So it's important to just kind of think about what purpose does the Constitution serve? And it can serve a lot of different things at the same time. It sets up a division of power, and we'll talk a little bit more about the three branches of government. It provides a framework for the authority of how does the government work, as well as within that, how does the government create statutes and laws that end up on the books, and then further through that, the regulatory world. It sets limits on the power of government, which is important to keep in mind. And then many of our state constitutions and state laws, and then the rules that we develop underneath those, do have to be consistent with the U.S. Constitution, in particular, the Bill of Rights. When we talk about statutes are, otherwise known as laws, are formally written documents that are enacted by the legislative branch of government and sent either to the president at the federal level or the governor for approval. So two different branches of government have to agree before, in most cases, before a law can be put into effect. And laws define terms, actions, and conduct. They can compel or require behavior or conduct, like you must get a license for this particular action. They can provide a framework for allowable conduct that in terms of what may happen within a licensed and regulated business or entity. And they can also prohibit behavior or conduct that says you may not sell certain products or, that kind of thing. Regulations, either at the federal level or the state level, need to be thought of as law writing, but delegated from the legislative branch to the executive branch, and that's to the agencies. And regulations have the effect of law. They are laws. They are basically enforceable as law, but the legislature has determined that it'd be better if the agencies write these further, more detailed documents and set up requirements. So they're promulgated by the regulatory agency that oversees the subject matter of the regulations.
Quick question, Brad. Can you tell us what promulgated means?
Yes, promulgated is a big legal word that essentially means written or developed. So when we talk about promulgating rules, regulations, and this weaves in a slide a little bit down the road here, but yeah, it is essentially rule making or rule writing. The basic principles, again, still talking about at the constitutional level, is that the power of the people can be restricted only by what's allowed under the U.S. Constitution and state constitutions, and that may include regulations and rulemaking. So, as we said, some states adopt a version of the Food Code directly into state statute. It goes through the whole legislative process, a bill introduced through committees on both House and Senate, and then sent to the governor. And some statutes may allow for automatic adoptions. And so when a new food code is officially done, it may automatically, but other state constitutions may prohibit that kind of thing. So many states, quite a few states, adopt the food code in whole or in part through the rulemaking process. And that's what we wanted to talk more about today. In terms of the form of adoption, when we talk about this, we talk about long form and short form. The long form is every word of the entire food code, and which is, as you know, there's a lot of words there. And that when we think about the long form adoption, and again, this may be because of state constitutional requirements that says that every word needs to be in this rule or in this statute. The short form may be adopting by reference, and that may be as short as either in rule, in this case, the 2022 Food Code with the supplement, and again, local requirements may vary, but it will then say that there's how to find it, because this then becomes part of that state's law. And so the public and the regulated industry does need to know how to find it, and needs to know with certainty which version is adopted. But also, a lot of states may include some revisions and modifications or exceptions, or not adopt certain pieces of the food code, and that is part of the process.
Brad, one more question. Are there pros and cons to each of these versions, long form versus short form?
Thanks, Deanna. Yeah, there are pros and cons, but they also, that may be irrelevant. If your state constitution says you have to adopt every single word, then the rulemaking process will then require you to use quite a lot of paper, or the document will have all the pages. And so in Michigan, for instance, we can adopt by reference and include basically we can do the short version, and basically have how we've done it is that in our state statute that is our state food law, there is a single section that adopts the food code, the modified version of it for us, and that allows us to not have to reprint the entire darn thing. So,
okay, I have one more question about this. Sorry. When it comes to long form versus short form, is there like a line in the sand as to how many modifications or revisions could be made before the type of form, the way you're adopting it changes?
I don't think there is necessarily. I think that's going to come down to, in some cases, it may come down to the legislative rules or the state statute that covers rulemaking. But also, we do have to think about the users, and that's both our field inspectors, as well as the regulated industry and the public that's certainly interested in food safety. So if we're trying to say we're adopting this part, but not these pages, but then this page, and then not that page, and only this paragraph out of that page, by that point, the scale probably tips to say, why don't you just do a longer form and adopt just the pieces that are going to be state specific. So at that point, I think that's where you ask your editors as well, is what is going to make this usable and readable for the final end users.
Absolutely. Deanna, one way to think of long form versus short form is simply a categorization. There's no hard rule when when you should do which, except for what your state requires. If you can't adopt by reference, you're going to have to go to the long form option in your state. If you can, but you make so many modifications that it's not useful, you may indeed go to long form also. So, those are just some general rules of thumb.
Yeah, thanks, Steve. So I had mentioned the division of power, the separation of powers before, and just as a refresher, is that there are three branches of government: the legislative branch, the executive branch, and the judicial branch. Rulemaking, as we said, is the delegation of legislative or lawmaking authority to the executive branch and to the specific agencies that have the subject matter expert. As a refresher, as laws get introduced, or bills get introduced, at the federal level, we have 100 senators and 435 members of the House. The legislative branch as a whole has to act. So one, either House or Senate, can pass something, but if both haven't passed it in its identical format, then it doesn't go on to the executive, either the president or the governor, to be considered and signed, vetoed, etc. So the executive branch is the president, is all the cabinet agencies, or the governor and all of the state agencies. And then we have the judicial branch, which is the Supreme Court, the U.S. Court of Appeals, district courts, but also then at the state level, a state Supreme Court, the Court of Appeals, district circuit courts as well. So the judicial branch is charged with reviewing and helping to settle disputes, including disputes over whether rulemaking was within the authority of the agency, was actually delegated by the legislative to the executive, or whether the rules are legal in the sense of even being constitutional. So this is we call the checks and balances of our national system. When we're talking about promulgating regulations and the whole world of regulations and rules, that is often referred to as administrative law. And this is based on the agencies who have to administer the laws and then the rules that are developed to fill in the details. And that's these detailed requirements of rules are necessary to implement or enforce the statutes. When you think about the time that the legislature has, and it's very precious, they have to cover lots of things. Some of our state legislatures are only in for a very limited number of days. They're not able to take testimony and go through the whole committee process for all the details. And think of everything that is in a food code, the version. There's a lot there. So this is part of that delegation. The regulatory agencies are given authority by the legislature to develop, promulgate these regulations for this specific area that they're charged with enforcing. And so that is fundamental, is that the provisions within our food law that allow us to then adopt a version of the food code are not going to give us authority over other parts of state statute. It's going to be specific to what we have been delegated. All of this is governed by the Federal or State Administrative Procedures Act, which is a statute that says how do rules happen. And we'll get into that in detail in a little bit. When we talk about, again, promulgating or developing rules, this whole area is called administrative law, and that is, regulations, rules, and the enforcement that come from administrative agencies that do licensing inspections and oversee this kind of law. The regulatory agencies are given statutory authority, and in addition to licensing and enforcement and setting up other standards as far as that goes, but then also to do regulations and to develop regulations and update them. But the process for that is going to vary. There's the Federal Administrative Procedures Act from 1946, or each state has its own provisions, which in statute and or in state constitutions about how rules get created and updated. So when we talk about, we'll then show you some examples of regulations. These can come of, there really needs to be a fundamental provision that says that and this is very timely considering the recent U.S. Supreme Court rulings that you may have heard of related to Chevron. We have to start. We can't do rules unless there's some provision that says that there is authority to do them. And that may be very specific, but that also it may be broad and general. So in this case, this is the Food, Drug, and Cosmetic Act, and Congress said in the authority is vested with the Secretary of Health and Human Services to efficiently enforce the act and may promulgate rules. They may be more specific, and the legislature certainly can put in timeframes and deadlines, like they did with the Food Safety Modernization Act that said the Congress set up a time frame that said within 18 months, we expect the secretary to develop, promulgate regulations about hazard analysis, preventive controls, but also important things to define who is a small business or a very small business, and what does that mean? And that's where this can be very specific in terms of, and may have to be, so that everyone knows what the agency has in mind as a proposal before it goes to public comment. State examples: the department shall, in accordance with the Administrative Procedures Act, adopt rules, and this is a direction, shall adopt rules. That may also be a may, but in this case, the expectation is the legislative branch says, we really need rules, we need specifics to set up minimum standards for entities covered under this. And we may adopt, again, by reference or with or without amendments. So this is for Health and Human Services, FDA, to promulgate regulations related to the Food and Drug and Cosmetics Act. Special conditions, these also may happen. They may give direction is in terms of the process. The Administrative Procedures Act does lay out a number of provisions, but this may also when this power is delegated, it may come with these kinds of activities as well, that you must consult with municipal corporations, affected state agencies, and industry. Not doing so may be a reason for the rules later to be ruled invalid if you haven't done the steps that you have to do as part of the delegation. And then as we talk about limitations on authority, they may also set up limitations. The legislative branch may say, executive branch, you must do rules, you need to cover these things, but you may not be able, but you may not do any rules related to this area, or you may be very specific, as this case, shall adopt rules very specifically for several kinds of mushrooms, and where they really want to make sure that this part gets taken care of, and that the agency doesn't develop rules that don't include these kind of standards, so that the regulated industry and the public know what to expect. So that's some background. Let me turn it over to Steve for getting into some principles and big picture items here. So, Steve.
Thank you, Brad. So let's talk a little bit about the basic principles of administrative procedure. So there's a handful of basic principles that we tend to see through every state and the Federal Administrative Procedure Act on the basic process. The first step is typically the regulatory agency drafts a proposed rule. That doesn't mean there can't be work done before, and often there is work done before that helps get information on what that rule should maybe look like, what factors should be considered, what difficulties there might be in that adoption or in that rulemaking, et cetera. That may definitely be able to happen depending on your Administrative Procedure Act prior to even the drafting of the rule and making it public. That then gets submitted for an administrative review process. Depends on who that goes to. On the federal level, that goes to the Office of Management and Budget, which is part of the White House. On the state level, that often goes to may go to your agency leadership and the governor's office for review prior to filing and formal submission. Once it's been through that review process, the rule gets published in some manner. Note the word published means something different today than it probably did 50 years ago. Back even 10 or 15 years ago, that often meant that it was actually printed in a book of some sort. In the case of the federal government, the Federal Register, there were equivalent publications at the state level. Many of those are now electronic only and only available online. So that's been a little bit of a change that we've seen over the last 15 or 20 years. Then the next step is always an opportunity for comment. So agencies receive comments through written submission and our public hearing, or a variety of mechanisms, or both sometimes. And those comments then are reviewed in the next step by the agency. And based on the comments received, a final rule is published then for adoption that becomes the regulation. Let's talk a little bit about each of those steps and a little more about what happens during that work. So in the pre-drafting steps, a few things tend to happen. Normally, the agency will have a regulatory coordinator or a general counsel that works with you on specific requirements for your agency or state. There may indeed be templates. There may actually be a guidance from the state code editor or administrative code editor or whatever, or revisor, as they're called in some states, that provide you style and format of what they should look like. It's important, though, in this pre-drafting process, you all get together with whoever is your coordinator in your agency and have a conversation and learn about what are your requirements in the state. Are there samples of things we can look at to do better, etc.? You may indeed be able to find, when talking either electronically quickly or by talking to whoever's responsible for the administrative code, the previous adoption document, which may serve as a format and beginning of what it might look like. In addition, many agencies are required to adopt an annual regulatory plan that lays out what are we planning to do this year. If you think this is the case, you need to make sure that that gets cycled into that plan. Federal level agencies are also required to do this. Most states have some sort of requirement for a regulatory plan that gives general notice to the community. We anticipate working on our rulemaking in this area this year. In addition, throughout this process, stakeholder engagement is very important. Smooth regulatory adoption normally means there's been a lot of discussion, a lot of work with the stakeholders in advance, so that so many of the concerns are identified on the front end. So definitely think a little bit about that and how can we have those conversations. Part of it is socializing. Maybe here's what the changes are in the new food code. Tell us what your thoughts are. Here's, and doing some of that in advance. That might be with your major associations, often the restaurant association, often a grocery industry association, sometimes the petroleum marketers or something like that that represents convenience stores may be different. But look at those associations. In addition, you may also have things like a farmers market association and those sort of things to think about. Make sure you engage folks in that early discussion. But that needs to be one of the conversation points with your agency regulatory coordinator or general counsel. What are the limits in that engagement for our state as we do a regulatory adoption? There are many different standards there and what you can do. Drafting a proposed rule, there are some key questions to ask. Are there any changes that may be more challenging for your state? Are there unique things to your state that make it difficult? For example, I'm going to approve source in Alaska. There may be some challenges. You may need to think about what do we do with traditional indigenous foods. We have some non-traditional food sources often in some states that may need to be considered. Are there unique things to my state that may require us to do this a little bit differently? Some states have things like a requirement for every regulation adopted, you have to repeal 2 pages of regulation. So understand what your unique state requirements are. Are there any restrictions within your state law that say that you can't adopt a provision related to this? So make sure to carefully examine your statute that's authorizing your adoption to see if there's any regulations or any restrictions related to that work. And then lastly, are there restrictions on how many things may be adopted by reference? Once again, what is our requirement as long firm versus short firm for our state? How many modifications are we making? Start making those decisions as we begin that drafting process. Continuing on, what is the requirement for pre-publication stakeholder engagement in my state? Many states have very broad requirements for pre-publication stakeholder engagement. So take a look at that. Some also have some modified rulemaking processes that make it easier, that are referred to as negotiated rulemaking. In other words, the stakeholders come in, and if you can agree to something, it makes it a much swifter process in the adoption of the regulation. Look at all of those things and understand that. Next, you may indeed be required to do an impact analysis that must be submitted with your rulemaking proposals. So those might be economic or fiscal. They might include what are the costs to state and local governments, what are the costs on regulated industries, what are the impacts on small businesses, what are the impacts on minority communities. All of those things are often things that you'll see as requirements that get submitted with the rulemaking package. Once again, looking for samples, understanding how your agency approaches that is another great question for you to have during that initial conversation. So definitely be thinking a little bit about that as you go forward. Brad.
Steve, I just, your thoughts, especially, one of the issues for us is that economic or fiscal. It's one thing to talk about and project how is this going to impact our own agency, but and a lot of, and some, it may or may not, but you should be able, that's a little more under our control. But any thoughts that you have on how you start tackling within an agency, how is this going to really impact everybody else for that fiscal analysis, which is important?
So great example. And actually, we do have a tool related to this that's posted adjacent to this webinar that provides you an Excel sheet that gives you some examples of how you might approach this analysis. I'm going to be real. Economic analysis are estimates. So let's pretend that you are for the first time implementing the requirement of manager certification training, and you're going to do as the code requires at all hours of operation. You probably can begin with some base assumptions to that. Most operations are doing what we might call two shifts. Okay, that gives us an idea. We're probably going to need at least, 2 times double that, times 7 if they're open 7 days a week. Those sorts of things. We can put in some guesses. We could also guesstimate what's the cost of a food protection manager course. How many hours does it take for them to take that course and travel to that course or do it online? Those sorts of things you can put some estimates in and get a very good idea. There are others that are much more difficult to estimate. If we do a change in temperature or require a certain temperature for hot water and those sorts of things, that's going to be a much harder thing to estimate. But think through that and do your best. We've provided you some examples in that fiscal analysis Excel sheet that will assist you as you're looking at doing these. And also the same with the local agencies. It'll give you an idea of how one might look at that going forward. But definitely, it is a very challenging thing, and recognizing most of us are not economists that specialize in doing something like this. It can be a challenge. Well, let's talk a little bit about a few tips during the rulemaking development process. Do find the previous documents that have been used to do your food code adoption, and they can often be used as templates. Do review the entire chapter section for other potential revisions needed. Often when you look at this, there are other things needed, and when you open up that section is the right time to do it. It might even be your address has changed and you need to update that, and that's often stated somewhere in administrative rule, or you might be doing something different policies that just never actually hit the rule. So let's make sure to fix anything that needs to be updated while we're at it. Do consult with agency resources such as the State Administrative Code Editor with questions. The State Administrative Code Editor is located in a variety of places, but the most typical places are the Secretary of State's office, the Lieutenant Governor's office, or the Legislative Staff office. And it may be called something different, and maybe the Revisor's office, but normally you can figure it out. If you can find the State Administrative Code, it'll tell you who's responsible for that work. Do have room when you're doing a proposed rulemaking to potentially have some nice to haves in there that may be negotiation options that get you what you really need in the end. I would always say, just like in statutory world, never propose what you really need on the first day. Always have a few extra items that you have some room to give on, because oftentimes you will have to make do some negotiation in this process to get to a final rule. Stakeholder engagement, as I mentioned earlier, is really, really important. Consult early and often throughout the process. Consider using your state or local food safety task force, food advisory committees, et cetera, to help with vetting the ideas for these proposals. Think about a potential webinar or Zoom presentation on the proposed rule, if allowed. Do consider using things like notifying via newsletter, email, et cetera, the regulated industry of the proposed rule change. Think through all of those things. Another thing that I think Brad and I would both tell you is, as part of that, also consider if your agency will work with you to do this. Once again, you have to talk to your agency. One of the things I typically did was do an outreach to the committee of jurisdiction at the legislature and have a conversation with normally the chair and the ranking member. This is what we're doing. This is what it does. You have any questions? And those just always help to make things go faster and not get some of those those late questions, and normally opened up the discussion with them quickly. All things that I think make the rulemaking process go better. But once again, it's important to have the conversation with your general counsel or regulatory coordinator to understand what happens in your specific state. Also, when you're drafting, make sure your agency communications staff are aware of the proposal and prep them for any potential media questions. In all likelihood, if this is one of the things the media follow, and as proposed regulations are adopted, they ask questions. So definitely be prepared for them. And if you have any questions, definitely, ask people. I'll look to others. My experience is, if you ask, people are almost always willing to help you and lead you through this process in a good way, whether that be in the code editor's office or your general counsel or regulatory coordinator's office. Brad.
Just on that, and I guess we're sort of assuming it, but to back up, because before talking to your legislators or anyone else, be sure, you definitely have to run this up through your own agency and make sure that in those discussions that your director, secretary, commissioner is supportive, and those same talking points, some of the economic analysis that you're going to have to do about, is this going to cost us money? Is this going to cost the industry's money? Will be something that your own internal chain of command will want to know, and your legislative liaison will then be able to use it to reassure your legislative partners that we're on track and we're thoughtful and we're of course following all of our steps. Your communications office, and so make sure as you're developing all this for the regulatory impact statement, and it all fits together.
I have one more question.
Sure.
You and Brad gave us a lot of great tips and things to do in preparation. Do you have anything that folks shouldn't do, or things that they may address too early that could inhibit the process further down the road?
I think my biggest warning statement is understand what your allowance is in working with stakeholders during this process and which steps you can work with them and which steps you can't, because that can actually create a very real problem quickly. So it may actually we could go back to the beginning if you did that wrong. I think that's probably the biggest thing, but I would say those early meetings and discussions with the agency to understand how the process works is critical, and absolutely do those. And I'll note, these folks are often very busy, and this may not be their priority of the week, but definitely reach out and have that conversation and do that very early. I'm going to say well before you're ready to start the process. When you're beginning to even think about it, you should be having those conversations. Oh, and this is not fast, by the way. I don't think we mentioned it, but in most states, you're looking at 6 months being a fast regulatory adoption, and some going well into a year and a half in process from beginning to end. So don't think this is going to happen tomorrow. It's not. In fact, I can remember when I was sitting the spot in Iowa, the absolute fastest from the time of filing to the time of adoption was 108 days. I have that number drilled in my memory at this point. I'm sure Michigan has a similar number that Brad has drilled in his memory.
Well, and for us, it's highly we'll get to this a little bit in a little bit, but the legislature sometimes gives itself a window to review in case they get word that things are not to their liking. So for us, it's 15 session days before a rule can go into effect that the legislature gives itself, which is 5 weeks if they meet all three, if both meet in that time period. But I think this, as you're embarking on this process, it's very important to understand the subject matter content, but it is really important, as Steve was saying, to understand the process. And when we're talking about engagement, especially with the regulated industry, there are provisions. Talk with your counsel about that, because we, of course, represent the people, and that's what the provision that I think that's what Steve was getting at, is that certain industry voices would love to help you write the rules, but while what they say is important, they're not ultimately the rule writers. I mean, they can comment, and they along with everyone else will comment once we get to that public comment period. But that's the real concern is having certain entities behind the scenes essentially do the drafting, and that's not their role. That's our role.
One other thing to note that is also a link on the website associated with this webinar is a link to the various style guides templates for the various states. While not all states have them, many do have clear templates and style guides as it relates to administrative rule development. So definitely take a look at those. Your state may actually have a handbook, which would be included in that, on how to do regulatory adoptions. So definitely take a look at those links and see if there's anything specific to your state. Just one more tool for you to use. And if you don't have any of those tools available, look at neighboring states. I will give you a hint. The states around you probably have relatively similar regulatory adoption requirements. It seems to be somewhat regionally based on how people approach it. So that may be another option. If you absolutely can't find anything from your state on the last regulatory adoption or style, maybe start with yours, with a neighboring state, and see what they did. And then maybe talk to the administrative code editor's office and see if this is a close, or what things would have to be different for your state. Okay, so let's move on to the next step. We have a proposal now, and we're ready to submit it for publication. When we get to that point, this is often the point in the process where there's a little bit less activity happening. This is often when your conversations are more limited to specific questions, but often less discussions of what would you like to see and that sort of thing are allowed to happen during this period of time. Those need to often be recorded and in the official record, so it's clear what was done. In addition, this would be when Brad mentioned, for example, you'd have the time for the legislative committee or the legislature to review. Also, in addition, you consider what needs to be done, and when adopted, start thinking about your implementation plan. Now you've spent all of this time developing the regulation and you haven't really thought about how am I going to put this into effect and what does that look like? So, there can be a lot to happen. The way each state approaches the legislative review process is a little bit different. Some have a more formal process, some have an informal process, some have committees that do that work. It all just depends on your individual state. Important to learn that in your initial meeting. I can give you an example. In Iowa, you appeared before a overall joint committee of the House and Senate with representation of the governor's office and the attorney general's office. And any of those folks could stop a regulation for a period of time from advancing. So it was a very interesting process, but that appearance before the committee was often the most important process in your regulatory adoption. When you walked them through what you were doing, others had opportunity to comment before them. There are equivalent processes in many states. So think a little bit about that. During the comment phase, as you're receiving comments, those may be via letter, email. Sometimes you have a formal mechanism site where all the comments go through. You may do public hearings or public meetings. Those can come in different formats. We're seeing a lot more Zoom options out there. Some literally are as much as a tape recorder sitting in a room where someone can walk in and do comments. I've seen all forms of public comment. Just understand what's normally done in your agency. Sometimes it's more formal, sometimes it's less formal. Just understand that. As those comments come in, think about how to organize or group the comments. You're going to have to respond in your adoption notice to the public comments. Some of the questions that you may get is you may say, hey, maybe I wasn't clear enough on something. I might need to be even more clear. Did they misunderstand? If so, do we need to clarify and educate? Were there unintended consequences we didn't think about in this? Those are often areas where you get lots of comments from the public. And consider whether revisions to the proposal are needed. One other thing I should note is during this comment period, and kind of the last slide is, you may want to think about doing some things that you might not have done 10 years ago. You may indeed be able to hold some Zoom informational sessions where you can talk about the proposal and what's included. Those sort of things are very valuable. I had a huge rulemaking a number of years ago where, right as webinars were coming into feature, and when I say this, it was like in 2014 or 15, when you weren't doing these every day, maybe even a little earlier, actually. Actually, it's probably 2008 or 9. Got it, a long time ago. But it was going to affect a dramatic group of individuals, and it was a big deal, and lots of industry. So we did do a lot of those public outreach events. I think we did 10 of them. Those webinars where we presented the rule, allowed for questions, provided feedback, and as much response as we could about technical pieces. What does this mean? Sort of questions. But it was a great opportunity and it worked very well. And I'll say, what was a controversial rule became much less controversial because we spent a lot of time providing educational opportunities on what the intent was. So now that we're through that in that public comment phase, one other thing to think about is rulemaking, like the political process, and this is part of the political process, is a give and take. You may have to give up some things, or there may be some things you modify that and that's part of the process. Try to not take it too personally if you have to change something. But that's part of what happens during this rulemaking process. No different than what happens if you're doing a legislative process, and also understand what's important. Think about what you really need to have, what is negotiable, what is not. Remember, your leadership will likely help provide some influence on what's negotiable and what is not. But that's also where it's kind of nice to have a few things that might not be popular, but that you're willing to give up in the alternative. So that's why I always like to have a few things that I know I can give that might be slightly beyond what is palatable to do during the administrative rulemaking process. So something to think about. Once you get through that comment phase, you've made your final decisions. You've started building your preamble, which comes before the adoption and is formally published, that talks about the process. We'll actually go through in the final rule and talk about what comments were received and how you address them and all of that. You move to your final prepared and submitted document. So once again, there will likely be some level of revision based on the comments. You must consider the comments and often provide that explanation. You must carefully consider your effective date, perhaps even a staggered implementation date for more challenging provisions and those sort of things. So think about this. There is a date when you publish your rulemaking final document that it can take effect. That is the first possible date. You may not want to use that. Often it makes sense to do this at a clean division point. I tended to use one of two dates when I was doing a regulatory adoption. It was either going to be effective January 1 of a year or July 1 of a year. We tended to not do, March 22nd as an adoption date just because it was a little harder. And often we would make the adoption date months out from when it could be, or sometimes even a year out. Another thing is if you have a particularly controversial provision, you may want to think about an opportunity for staggered implementation. So, for example, you may have for new establishments, this is the requirement. For old establishments, it's if this happens, you have to meet this requirement, and those sorts of things. Think about a potential for staggered implementation dates. Sometimes with certain provisions that can make it much easier to move those through if you do something like that. Just remember, once again, here, many levels of approval may be required. It may have to go to the agency, the governor's office, the Board of Health or Agriculture, through the legislative review process and approval process, again, just like we talked a little bit about before. But understand that from your earlier conversations, what levels of approval and process have to happen. As we mentioned, this is a delegation of the legislative branch's authority, and you're only allowed to do this to the extent of state law. The legislature can always change and override in some manner your regulations, whether doing it formally or changing the law and prohibiting you for doing that. We note that legislators in most states are part-time folks and not always there working, so not always they're available. So they have some sort of process normally that ensures that this review option is available. Full-time legislatures may have a different process, like Brad mentioned in Michigan, that they have the 15 legislative day provision. Those sort of things vary between states. Once again, very important to understand. So the next question you get to is, if you don't follow your process, there are potentials for legal challenges of regulations. The most common challenge, well, one, if you don't follow the process established, that is problematic when you hit a challenge. Let's just be, if you did not follow it, you are more likely to have a situation where there is a problem with that regulatory adoption. You may have to start over. The second thing that tends to happen, or tends to be the question, is, did the agency exceed their statutory authority? In other words, their delegation of what they could do. If you have a clear delegation to adopt the food code with modifications or whatever the case may be, probably not so hard in this context. But there are others where it's, can be more challenging, and the language may not be quite as clear. And so make sure that, be very careful to narrowly craft your proposal within your statutory authority. The second thing that most folks get in trouble for is the agency's action was arbitrary or capricious. So this comes when it's unclear why the agency made such a decision. The evidence, the comments, etc., may not have supported the agency's final action. When you get to those situations where it's unclear or murky, sometimes a court will use that will determine it's arbitrary or capricious. It's not based on the facts. It's not based on maybe the body of knowledge at this point, etc. Then you hit that. It's not particularly common, but it does happen sometimes. Normally, though, you'd have a pretty good idea if there was that potential. You'd see a very broad bunch of comments arguing, let's just pretend that you decide to set the temperature for hot holding at 180 degrees. that might be something where people would come and say, well, that's arbitrary and capricious. That does not make any sense. It's not supported by science, not supported by best practice. Your evidence doesn't support this. So that might be an example of something that where you'd get to that. Lastly, of course, follow the steps of the process. Make sure you've done that. Brad, go ahead.
Well, and it's important when you think about the public comment period. I did want to mention that the public, and that public includes regulated industries, is really important to consider what they're saying. We don't have to. I mean, we don't necessarily have to do what they're asking. Sometimes, I mean, we live within, though, a elected leadership world. So there's balances there. But again, really important to know what the process is, because that third bullet in particular, you don't want to go through all of this and then get challenged because your regulatory impact statement was only available to the public 44 days and your statute requires 45 days. I mean, that almost makes it too easy for the people who don't like this rule to get a judge to say, do over. And I did also want to say there is a possibility, that you may get so much public comment and so much feedback and so much pressure that you may have to really change some of the scope. And then again, it depends on the jurisdiction. But if the rule coming out of public comment is significantly different than it was going into public comment, which it may need to be, there may be a lot of good reasons for that. There may be go back several steps and go back to public comment, because when you think about it, the public who might have cared didn't know that you were going in this direction, and that's why they didn't comment. And now you just changed directions. If you had nothing in there about bare hand contact and then got public comment to put in or take out, whichever way, then that addressing that public comment may also force you to back up a step or two and then keep going.
Yeah, no, and I will say I've used all those tools when I'm doing rulemaking at times to, if I'm making significant changes, go back and re-notice it for full comment. Very good practical step. With food code adoption, I think that would be less likely, but it's definitely possible if you're adopting very significant provisions, or if you're doing pretty significant modifications from maybe what I'm going to call the standard, the FDA Food Code. Definitely things to think about. Well, kind of our last step of the process is, once again, understanding, and I emphasize stakeholder relationships a lot because I believe it's one of the most important things we can do as it relates to both the regulatory and legislative process. All relationships have lots of advantages. Having robust amounts of public opportunity for public feedback and discussion of upcoming changes is very important. Building that legislative buy-in and understanding is really important in the development of legislations. And lastly, discussing in concept when you're meeting with folks, doing presentations to stakeholder groups, starting to say, we're thinking about, we're moving toward, those sort of intention language, but not getting into a lot of detail. Hey, we're moving toward the adoption of the 2022 Food Code. Here are some of the major changes that are in it. We don't have a time frame yet, but it's coming. Type things. Give them, once again, an opportunity to start preparing. Like everyone, most folks can do almost anything, but having some of that acceptance time becomes very, very important, particularly with major provisions. So definitely think about that and give them early opportunities. And think about what tools you already have in place to do some of that outreach. You might be doing an annual presentation to various groups as part of the State Restaurant Association conference. You might be doing a presentation to the school nutrition directors, or those sorts of, think about what groups, or as it might be doing something with some of your local consumer groups regularly. So think about how you can incorporate that into everything you're doing as you prepare to do this to start building those expectations and use all those tools possible. With that, I think I'm going to ask Deanna, did you have anything that you wanted to ask about before we wrap up for the day?
No, I think you have covered everything. I got a few bottom line points out of this presentation, which is, do your research, start early, and manage your expectations, because it is going to be a challenging process with lots of ups and downs throughout the way. Brad, did you have anything else?
This really requires a lot of skills, but is something that other people in your agency have done. And so be sure that you're engaging and not feeling like you're in it all by yourself, because you're not. Rulemaking is a team sport.
I would agree with Brad totally there. That consultation with others in your agency becomes so important. I think the other thing is, I know I mentioned a lot of times, but stakeholders are key in this. Even controversial provisions can move forward with good conversation and working together. That's when you might use some tools like the staggered adoption dates and those sort of things, and understanding what their concerns are. I mean, for example, there may literally be a capacity issue to do what you want to do in the time frame you want to do it. And if that's the case, you may need to readjust your expectations and do it more over time than immediate. So just be thinking about those tools that you have that can still get you to the ultimate impact, but it might just take a little longer, and what you can negotiate on. I think both Brad and I have done a fair number of these over time, and some of them controversial and some of them not. This is one that typically is a little bit less controversial for most jurisdictions, particularly if you're not making huge changes between food codes. But you always have to be prepared for the more challenging adoption, because sometimes there's a provision you just don't know, you don't expect it, and suddenly becomes very controversial. So I'm always surprised at what sometimes people have strong feelings about that you don't expect.
Oh, and that's where the local component is really important. And I mean, the food code itself is built in with this. I mean, it is not a rapid, fast thing that gets changed. I mean, it takes that is an important selling point when talking back to legislators who may not know what the conference does, and how national level industry groups and states and health has played a role in developing this model document. So some of that, don't assume that some of your stakeholders understand where this even came from. Some of your industry people may have been very involved and be involved in the development of the food code itself. But then when you get into a small state level association, your ice producer, company may not be plugged into this. They should be, but that's where you'll find out, when they say stop the press is what's going on, and then you just have to be sure that you're trying to address their questions and be able to explain the subject matter as well as the process.
Absolutely. Well, Deanna, I think with that, Brad and I, if you have questions, I'm happy to address those to some extent, but ultimately it's going to be your agency, your general counsel, your code editors or revisor's office that you're probably going to need to have some conversations with to understand what are the specific requirements for your state. Note, there are a couple tools available for you. One, we do have the links to the various style guides for administrative or regulatory adoptions. Two, we also have available to you the fiscal analysis tool that you can look at using. So those are great ideas. And of course, I know we're mentioning another webinar, but don't forget the Food Code Adoption Toolkit, which also has other tools that may be helpful in your regulatory adoption on how to move forward and give you some ideas of how you might move forward. So just don't forget those other tools, and all of those are linked to this webinar also.
Yes, thank you for the information. Thank you, Steve and Brad, for sharing. I hope this is super helpful for all of our participants to prepare for food code adoption, because it sounds like a very big lift, but with big rewards also. So thank you for watching. Check out the AFDO website for those tools and email us with any questions you may have. Thank you.